All right, let's get into it. So today we're going to be going over the addendum O, the addendum R, and the addendum S. Um, so the addendum S, I've got a lot of some of you are seasoned down here, so you're very familiar with the addendum S, of course, but maybe want some refreshers on the addendum O and the addendum R. So let's get into it. I'm going to start with the addendum O today. And as always, stop me at any time with questions. The addendum O is in our zip forms, of course. It is not automatically inputted into our packets. So just an FYI there. In terms of if you need to use it for an offer to purchase, you would need to grab it from the WRA library. And if you just start typing it in, addendum O, it should pop up for you. Maybe. Here we go. It's right here. And it's highlighted in blue because I've got it in there already. But if not, I would just be clicking on that to add it to my transaction folder. The addendum O, again, is for addressing situations where there might be a post-close occupancy agreement or a pre-close occupancy agreement. So, in the case where a buyer might occupy the home prior to closing, I would say that is much, much, much less common than a post-close occupancy where a seller becomes the quote unquote tenant and rents back from the buyer after closing. So, if the seller wants more time to move, let's say they don't close on their place for another week and they want the time to move. Sometimes a situation could be where a seller has not even identified where they're going to be moving next. So I've seen post-close occupancy agreements for months at a time. So it really can run the gamut of, what kind of situation it could be. It's sometimes it's as little as 2 days to allow for that moving and cleaning to happen, all the way up to months. So there is nothing that's typical, except for the fact that a seller post-close occupancy is much more common than a buyer's pre-close occupancy, where the buyer is actually moving in ahead of time. So the addendum O looks like this. So again, starting at the top, this should all look familiar. You're going to put in the date of the offer, the buyer's name, and the address. We've seen this verbiage before where it's including of optional provisions. So just a reminder that if it's an open box, it's not a part of the offer unless there's an X or an NA. I always like to take the opportunity to say that if you are not including a provision, that you should still say NA. And this is true of all of our forms. I just really like to be able to demonstrate that we have addressed a section with our clients, right? So instead of leaving it open, let's mark NA for good practice. All right, so then premises occupied. So this agreement relates to the following premises. And I've never seen it where it would be different than the subject property. So you're just going to restate the property there. I can't even think of a situation right now where it would be not the property in question. I'm sure it'll come up. The occupancy period. So starting at line 9, the occupancy period is delineated as follows. Check the box at line 11 or at line 14 and complete. So I'm going to just show what it is for a post-close occupancy. So the buyer/owner grants to the seller, who becomes the occupant, post-closing occupancy at the premises beginning at closing and ending on, and then this is where you're going to identify a date. So we could say maybe it's they want through Black Friday, and you could name a time here. Most often it would just be till the end of the day, so you could just say 11:59 at night. Um, or I have seen it where it's like a 3 p.m. occupancy, like maybe it's, just till the next day. They want a post-close occupancy. You could literally identify a time of like 3 or 4 that the seller is going to be out of there. Um, and then the new buyer slash owner can take over at that time. So occupancy charge now, we're going to identify the amount that the occupant shall pay per day of the occupancy which will be held by, and we can say buyer slash owner here. And this is going to be credited to the buyer at closing. Payment is due at the beginning of the occupancy period, so that's typically closing. Any unearned portion of the occupancy charge is or is not refundable based upon actual occupancy. So it is refundable, it defaults to refundable. That let's say a seller was granted 2 weeks of post-close occupancy. Let's say that seller only occupies for a week. With this language, it's stating that that other week that they did not use could be refunded back to them. So again, this is all negotiation points, but generally speaking, I would say a buyer is just fine with returning the money, returning the unearned portion of it. So security deposit. Oh, and actually, let's talk about how to determine what the per diem amount would be. So again, this is a daily charge, and oftentimes a buyer's agent will try and roughly figure out with taxes, well, principal and interest payment, taxes, and insurance, what that buyer is going to be paying per month to own the home, and then dividing that by 30 to come up with a daily amount. That's usually what I'm seeing as the figure. But again, all of this is a negotiation point. I'll say too that in highly competitive situations, we've seen buyers just say, hey, Mr. Seller, you can have as much time in a post-close occupancy as you want, and we're not going to charge you anything. So I've seen this as at zero as well. So security deposit. So again, this is going to be a case-by-case basis on whether or not the buyer wants to include a security deposit, and it essentially acts the same way as any sort of rental situation. This is not a rental situation. I want to make that clear, but in the sense that, the buyer slash owner can hold on to a security deposit and refund it to the seller or occupant at the end of their time there, and determining whether or not they need to withhold any of the security deposit amount based off of move-out repairs or any damage done to the home based on a move-out. So again, I think that a lot of this is determined by how long a the seller might stay. So if it's a 1 month period, and it might be determined that it's a more hefty amount of a security deposit. But I guess again, I kind of want to give guidelines on these things just based off of what experience, what we've seen in our offers. But I would say it's 500 to 2,500 that we've seen for security deposits. So again, just transaction based. So then I do want to make the point here that we as the brokerage are not going to be holding onto security deposits. So if it can be worked out that the title company will hold on to it, great. Or the buyer owner will hold on to this and then issue them the security deposit after the occupancy period is over. So that is something that if we see, in our compliance review process um, that the firm, us, Keller Williams, is to hold on to the security deposit, we will kick it back and require that it be amended to reflect something different. So please make sure that you're saying the title company or the buyer slash owner. So payment is due at the beginning of the occupancy period. Owner may withhold for occupant damage, waste, or neglect, but not for normal wear and tear. Property taxes. So real estate taxes for the premises shall be prorated through the day prior to closing or the occupancy date. If neither are stricken, then they're going to be prorated through the occupancy date. So that seller would credit the buyer back, for the time that they also lived in the home in that occupancy period. It defaults to that. Otherwise, you could strike it so that it's just going to be prorated as normal through the day prior to closing. Condo and homeowners fees. So if the premises is a condo or subject to a homeowners association, either the occupant or the owner shall pay all condo fees, and it defaults to occupant here as well. So again, a negotiating point. Typically, I would say we're just leaving these to the default options of the owner paying for the condo fees. Same with utility charges. So the occupant shall have all the utility services rendered in their name. So the seller, they're going to keep their WE energy bill, for example, in their name through this occupancy period. And they must pay them as they become due. Utility services include electricity, gas, water, and sewer. To the extent that this cannot or is not done, utility charges shall be prorated based on the occupancy date. So like water, for example, that would just become another prorated charge or credit because we're not typically paying those in real time. So maintenance, occupant shall be responsible for all routine repairs and normal maintenance of the premises and personal property included in the offer during the occupancy period. So the occupant shall maintain the premises, including any heating, sewer, plumbing, and electrical systems and built-in appliances and equipment, exterior and the grounds, and their personal property in reasonable repair and normal working order during the occupancy period, except for ordinary wear and tear. Any changes agreed to by the parties. So maybe something else is worked out during the inspection period. So the crux of this provision, any major repair or maintenance item shall be the responsibility of the owner, and we need to identify a threshold amount. So a major repair or maintenance item is anything costing more than X per repair. Any other repair or maintenance item shall be the responsibility of the occupant, and disputes regarding major repair or maintenance costs shall be resolved based on an estimate provided by an independent third party. So really what we're identifying here is, so now the buyer slash owner, they're now responsible for the mechanicals in the home. So this is where, we've seen disputes around this in a post-close occupancy period. We need to identify, okay, so if the water heater goes out in the post-close occupancy period, who is going to be um, responsible for that? And we're going to look for this threshold. So typically, you guys, I'm not seeing this amount to be very much. Once closing happens, then, it's presumed that the owner is taking care of those mechanicals as they would as if they lived there. The same way, we don't charge our tenants for repairs that happen in a typical rental landlord situation. So anyway, I guess again, it's always a negotiating point, but I would say I'm typically not seeing this threshold amount to be, more than a few $100s. So, if something major comes up, then it's going to be at the expense of the buyer slash owner. And if anything is less than this threshold amount, then the seller slash occupant is going to take care of it. So, um, any questions so far? Okay. Keys. So, this we're just identifying how many keys each party has. So during the occupancy period, the occupant shall have, and I'm usually saying just one set of keys to the premises, and the owner shall have, and you can say two or more. I don't even know if you can put a key shall include any fobs, codes, and digital keys. An owner shall be admitted to the premises at a reasonable time upon a blank notice. So I'm actually usually saying 24-hour notice instead of leaving it to the default of 12. Um, and so again, in a kind of like a traditional landlord-tenant situation, that seller can't just come in, sorry, excuse me, that buyer slash owner can't just come into the property because it's theirs without giving some notice to the seller. So, um, yes, I would identify, again, it would be left at 12, but you could identify more. Removal deposit. This is kind of an interesting provision. This replaced, in the old addendum O's, it used to be the case where we could identify a daily charge that would be levied upon the seller if they were to go past their occupancy period named on the first page. So in that, November 28th, we've identified that that's when the seller is going to be out. And if they're not out, then they're going to be charged a daily charge of X amount until they do move out. So kind of just like getting ahead of squatting or that sentiment. Now it is one lump sum, and we identify that ahead of time, and it's held with, again, the buyer, sort of like the security deposit, and is refunded to the seller once the occupancy period is over. So, and again, this is to prevent that seller from staying longer than they've agreed upon. So you could say buyer owner here again. And again, you're kind of coming up with that amount. So, a seller, this is a high amount, a seller's not going to want to pay $1,000 if they're going one day over their occupancy period. I don't have like a good guideline for you guys in terms of what to use for a removal deposit. Um, a lot of times I will see this blank if the security deposit is reflected. But again, this is not like the security deposit in that, as soon as that seller vacates the home on that agreed upon date, then they would expect to get their full $1,000 back. Again, that's to prevent those from staying longer than agreed upon. So, um, I wish I could give you a good guideline on that. And I don't know that it's reasonable to charge thousands of dollars for something like this. So, but every transaction is different. Um, and then it gets into failure to remove from the premises, and it gets into legal action, optional legal action. I'm not going to go through this line by line, but this is where we'll consult our attorneys if that's the case. And again, too, this is a roadmap for buyers and sellers. And if it's a post-close occupancy period and it's past closing, a lot of times not a lot of times, we're removed from that because it's in the post-close occupancy period stage. Use of premises. So occupant shall be entitled to peacefully and quietly have, hold, and enjoy the premises during the occupancy period. Occupant will make no changes, alterations, or improvements to the premises without the prior written consent of the owner. And then the occupant is prohibited from assigning or subletting their occupancy rights under this agreement. Hold harmless, so the occupant shall hold the owner harmless for all liabilities, claims, or expenses resulting from the occupant's use, possession and occupancy of the premises as described in this addendum. Parties agree to hold harmless any person or entity harmless for good faith disbursement of any security deposit or removal deposit per the terms of the addendum. Then it outlines again that this is not a landlord-tenant relationship, so that they're outside of the statutes that govern a typical landlord-tenant relationship. So we can't look to those statutes if there's any disputes in these cases. Insurance. So insurance may not be available for the occupancy period. The parties should consult with their insurance agents regarding availability and cost. The insurance requirements, if any, for this occupancy period shall be blank. So I would again consult with a insurance agent on what a typical occupancy, like post-close occupancy insurance provision might look like. Um, it is not the case where I don't, as far as I know, it's not the case where a seller would or could take out like a renter's policy, or that the buyer could require the seller to take out a renter's policy. So we're just going to look to our insurance experts on these. The buyer slash owner would have their typical homeowner's insurance in place as of the date of closing, because they are the owner of the home. But it's just, again, as far as any like insurance policies around personal property for the seller, we would just need to consult with our insurance agents on that. Okay, so then, like any addendum, we would have all parties initial as acknowledgement. And then also, just like any addendum, any provision in here is negotiable. So if it is a counter situation where, there's a disagreement on terms of the addendum O, you could put that into a counter offer. Okay. Any questions? Awesome. Okay. Then we're going to get to the addendum R, which is used in the case of multifamilies. I don't know that I have an addendum R. I don't already have one in there, so I'm going to add it now. Little zip forms training for you. Okay. Okay, so again, we would use this in the case where there are rental agreements. So your 2 families, 3 families, 4 families, we could add the addendum R to the offer to purchase if deemed necessary. Again, it's not required, but it just covers and expands upon some provisions in the offer that we can use. Again, addendum is made part of the offer, dated X, made by the buyer, with subject to the property at, and then you're going to name the address there. This property is subject to rental agreements, either written or oral leases for a definite period of time, or oral or written rental agreements for periodic tenants, such as month to month, who pay rent on a periodic basis. Buyer takes the property subject to the tenant's rights, meaning, if there are leases in place, either written or verbal, the new owner takes over those terms, and those rights, those tenant rights, those tenant leases survive the closing date. So it's not as if the new owner can come in and kick them out earlier than their agreed upon lease end date. The tenants get to keep those end dates in place as normal. Rent schedule. So beginning on line 7. Parties agreed that the following property rental information is current and correct with respect to any leases and any month-to-month tenancies or other periodic tenancies, whether written or oral. And then you can just, again, kind of outline the loose and main terms of a lease here. Rent amount, when it ends, um, rent due date. So you would just name like the next month, what the security deposit is. If there's any delinquent rents, you would name the amount, and then any penalty fees that are due. Typically, assuming that the tenant is not delinquent, then you would just be filling out these first columns and leaving these blank. So hopefully you would have a line of sight to what these lease terms are prior to submitting the offer. If you don't, we're going to get to that, but they can be furnished after the fact. But if you can get a good basis or, of the basic terms ahead of time, that's where you'll fill this in. All right. So then you'll fill that out accordingly. Beginning on line 21, leases. So complete copies of all current written leases and all rental applications received for current tenants are attached to this offer or shall be furnished to the buyer within blank days of acceptance. So you're going to strike one. So if you did happen to get a copy of them ahead of time, you're just going to strike out shall be furnished to the buyer. If it's the other case, then we can strike attached to this offer, and then we're going to identify the amount of days that we want to see those leases provided to the buyer. I typically do 3 days after acceptance so that my buyer can review those right away. If the buyer does not receive these documents by the applicable deadline, or if the lease terms or rental applications are materially different from the seller's representations, or do not comply with the applicable law, the buyer may deliver a written notice stating the seller's noncompliance to the seller within blank days. So, let's say we outlined these basic terms up here, based off of information we found in MLS. We don't actually have a copy of the lease and we get it, we review it, and it's drastically different than what's named, then the buyer may deliver a notice stating that they are declaring the offer null and void. So it's pretty good protection for the buyer. Personal property, so we can outline all of the different appliances, etc. So, if it's just a 2-family, we can assume, 2 refrigerators, 2 stoves, maybe there's only 1 washer and dryer, etc. So we can name it in the offer to purchase itself, but then we can also use this as well. The total value of these items is, usually I'm seeing this blank. If a lender pushes back and they want to make sure it reads 0, but often we're just seeing these items as included as part of the purchase price. Indemnification at closing, the seller shall assign all right, title, and interest in the leases to the buyer, and buyer shall assume all of the duties and obligations as the landlord. The buyer shall indemnify and hold the seller harmless from any claim or loss from arising events occurring after closing. So that's a protection for the seller, saying, my hands are washed. I have transferred these leases over to you as a part of the sale. So you're holding me harmless of anything that might occur with the tenants after closing. Rent. All rent for the month of closing shall be prorated through the day prior to closing. So just like taxes are prorated, just like water bills are prorated, rent is also prorated. Security deposits are just transferred in full. So if I collected $1,000 security deposit from my tenant, I'm selling the duplex, I'm going to transfer it to the new owner, and then he's going to do with it what he will based off of any damage that might have occurred when that buyer or sorry, when that tenant vacates. So those are not prorated, those are just transferred over in full. All right, and then more provisions here. So maintain rental operations. So unless otherwise agreed to by the parties, the seller shall give delinquent tenants appropriate notice of default and evict tenants who fail to timely cure their defaults, sue evicted tenants for delinquent rents and damages in excess of security deposits and repair damaged units. So this is stating that the seller must do that um, uh, if this is the case in terms of their tenant situation. So it's a good protection for a buyer to make sure that the seller is not just washing their hands of their duties prior to a closing. Vacant units, except as provided on line 67 to 70, the seller shall or shall not rent any vacant units. So this is a good one for a buyer who, they might have picked out a certain duplex as a potential owner occupant scenario. So if there's a vacant unit, that buyer might say you're not going to rent out this vacant unit at any time prior to closing. So we'd want to make sure that that's stricken to reflect that. We see that a lot where a buyer they might prefer to have a vacant unit. If maybe it's an extended closing, the buyer is going to be using this for rental purposes strictly, they might want the seller to take steps to get that unit rented. Generally speaking, I think buyers want control of that. So maybe there's an opportunity for a below market rental rate to be increased, and then the buyer can take care of that after closing. The change in tenant status. So seller shall give buyer prompt written notice of any tenancy termination, unit abandonment, tenant plans to vacate a unit or a material breach of lease terms, continuing for more than blank days occurring after the date on line 1. So this is just saying, and it's defaulted to this, if something happens with one of the tenants, you have to let me know, Mr. Seller, and keep me apprised of the situation. Again, that's a nice protection for the buyer. Rental agreement extensions and renewals. So seller shall not, without the buyer's written consent, renew an expiring lease or extend a lease term, change the terms and conditions of a lease, a month-to-month tenancy or other periodic tenancy, or enter into a written lease with a month-to-month or a periodic tenant. Again, a good provision for a buyer. Security deposits. The seller shall transfer the full amount of all security deposits to the buyer at closing without offset unless otherwise agreed. So I kind of went over that above. Tenant records, the seller shall give the buyer a copy of all the tenant records at closing, including any check-in reports. Notice of contact person changes. So this defaults to the buyer. The buyer shall give all the tenants written notice within 10 days of closing, advising them of the sale and all the new contact information for the rent payments. I'm generally seeing, yes, that the buyer is going to be giving this notice to the new tenants. Though I will say, a lot of times I'll see in our offers where a buyer would want to make sure that and generally sellers are doing this, but can you please make sure it's known that ownership is changing? And asking the seller to make sure that they're at least advising their tenants of the potential ownership change. Eviction. After closing, the seller shall complete any eviction action begun before closing at the seller's cost, unless the buyer at buyer's cost moves the court to be substituted or joined as a plaintiff. If seller gave tenants notice prior to closing to vacate the premises and the tenants have failed to timely comply with the notice by the time of closing, the seller, it defaults to the seller, shall take steps necessary to remove the tenants, including the filing of an eviction action at the party's cost. Again, just kind of another CYA for a buyer, which is nice. So it's saying here, the seller shall start that eviction process and see it through. Delinquent rent collected. Any delinquent rent or fees collected after closing pertaining to rent due prior to closing shall be paid to the seller's account. So this is nice for a seller. You know, if there was delinquent rent and they closed with that delinquent rent still outstanding and the buyer slash owner is able to collect it, they need to pay it to the seller after closing. The following provisions are a part of this addendum only if marked such as with an X. So then there's these additional provisions, requested vacancies. So the seller shall give all notices necessary to terminate the tenancy of the tenant in units, and you can identify the units, so that these units will be vacant at closing, and then you're going to name the closing date. If these tenants do not timely vacate the premises, the seller shall be responsible to take the steps necessary to remove the tenants. This might be an aggressive request, and might only be possible depending upon the tenant's lease terms. So those are, I think all of those would be conversations that you would have with the listing agent prior to even filling out the offer. So new vacancies. So if one or more units which were occupied on the date on line one of this offer are vacant on the day before closing, the buyer may deliver to seller a written notice of termination, and this offer shall be null and void. So that's again kind of aggressive. If for whatever reason that buyer took over, you know, they're taking over a lease and they're counting on that income, and then it so happens that the that unit is vacant prior to closing, they can say to the seller, well, this was part of the deal. This is part of why I had opted for this particular duplex. And now this is vacant, so I want to deliver written notice declaring it null and void. So that's also an option for a buyer. Okay, and then any additional provisions that you want to see in there can be written in. And again, all buyers and sellers will initial, but just like any addendum, as I had said with the addendum O, all of this is negotiable. Some of this is just outlining things. But if there's any provision marked in here, a seller could counter it out if they wanted or attempt. You know, it's a negotiation point. Any questions? We got a chat. There is no addendum R. How do security deposits get refunded? I recently had a buyer agent not include an addendum R, but requested it to get handled outside of closing. Would you just suggest this to be included or optional? So even if an addendum R isn't used, that security deposit should get transferred at closing, and then it's refunded by the new owner as normal. So I've never seen it any other way. Do you want to chat through this, Ms. Vieri?
Hi, can you hear me?
Yes.
Hi. No, I typically always include addendum R's
Good.
and this just to avoid, buyers and sellers not doing what they're supposed to do because that was the situation that I had on a sale. So I was on the list side and it
Okay.
was no addendum R. The seller, I explained, hey, there's no addendum R. They wrote it in as a additional provision on the offer to purchase, no addendum R to be included on this purchase transaction. I was never really told why. I'm assuming it was because they needed rental income to qualify, and the rental rates were below what the lender wanted to see. So I think
Okay.
they handled paperwork with the lender, I don't know in what manner. But when it came to the security deposits, I explained to my sellers, like, hey, typically with the Dendamar, you do have to refund them. In this situation, you're just going to have to handle them outside of closing because we removed them from the seller's CD. But then it never happened. The sellers just refused to, refund them. And at that point,
When you say refund, so when I hear the word refund, I mean, I take that as refunding it to the tenant. But you're saying the sellers refused to transfer it?
yeah, yep, to the
Okay,
buyer, to the new buyers slash owners.
got it.
So I
Gosh.
just found that a really difficult situation. And that's why I was curious after that, is it
Yeah.
required to do an addendum R?
Well, it's not. But so I guess my experience is that the title company is um managing that piece in the sense that they're getting copies of the rents. Okay, like this is what, or sorry, they're getting copies of the leases, and so they're looking to the lease to help, you know, fill out the closing statement. And they're gonna see, okay, so there's a security deposit of X, and then we're going to prorate the $800 rental amount, based off of closing date. And then I've just always seen it that they're just gonna automatically put those lease terms on the closing statement. I am gonna
Yeah.
I'm gonna look to the offer to purchase real quick to see. Um, and maybe this is where, if there's not an addendum R, you could, as the listing agent, be more specific here where it says,
Because I think on the offer to purchase, there's a section where it says lease, like
right.
the lease provision. They're right there, lease
Yep.
property.
So if the property is currently leased and leases extend beyond the closing, the seller, yeah. So this is automatically built in. So the seller shall assign the seller's rights under the leases and transfer all security deposits and prepaid rents under the buyer at closing. The terms of the lease are, and you can choose to fill this out, but it's it's stated that a security deposit would be transferred.
Transferred.
Yeah.
Okay.
So I would be pointing to this to our seller who, and
Yeah. Who's refusing to?
yeah,
Okay.
and the title company might have a say in that too. Like we can't close without um transferring that security deposit.
Got it. Okay.
But
I
it's
know in this situation, the lender, the day of the closing, an hour before, they're like, nope, you need to remove it. And I'm like, but I would prefer it to be on there. That way we
the
avoid.
lender said that.
Yeah, the lender requested title company remove the security deposit, which I was like, why? I would prefer it to be on there.
Okay. Well, we should talk more about it offline. But I just want
But
the
I'm gonna note that line 426, if that ever were to happen,
yeah.
I'll just reference that.
Okay, yes. I was gonna say, I mean, I've never seen it otherwise. A lot of times addendum Rs are not used. So,
Okay.
I think this is a good still, thanks for listening in, guys. I think this is still a valid question for you guys to hear as well. So, okay, let's get to the addendum S and then we'll round out the morning. Where's my addendum S? Another question. Oh, yes. You're welcome. Ah, okay, so this is the lead-based paint disclosure. This is required for all properties built prior to 1978, and it is essentially disclosing the possibility of lead-based paint on a home before the guidelines were changed on paint. And so the existence of lead-based paint might be present. Um, I will say you guys might see this Addendum S included in properties built after 1978, and that's just fine. If it's there and included in an offer, it is fine to still include it, even if, oh geez, even if it's built after 1978. So the first section, well, first it's a lead warning statement. So every purchaser of real property on which a dwelling was built prior to 1978 is notified that such property may present exposure to lead from lead-based paint. And then, this includes or is most affecting children and describes the behavioral problems that might be that children exposed to this might be at risk for. So then on lines 10 through 11, you're going to indicate the property. And then on the remainder of it, the seller of this first section, the seller is going to disclose any lead-based paint that they have knowledge of. So even with homes built prior to 1978, a seller might not have specific knowledge that lead-based paint is present, and that's because they have not gone out and physically tested their property for lead-based paint. So 9 times out of 10, a seller might be indicating none here on line 14 and none on line 20. Again, even though it's a home built prior to 1978, and there likely is lead-based paint, under layers of other paint, they technically do not have knowledge of it because they did not go and have it physically tested. In the cases where the city might make a mandate against a property to have lead-based paint tested, we have seen this before where there was a city, and it was a specific property owner observing that the home was in disrepair, making it a requirement for that particular owner to get lead-based paint tested, and then that seller does have knowledge because they did go out and have it physically tested. So if you know of a case where a seller has had lead-based paint tested and this is not filled out, we need to make that disclosure if they don't. And we need to go back to them and say, hey, this is inconsistent with what you have told me about the property. We need to update this, and we need to disclose that we do have knowledge of lead-based paint. You might have the sense that I'm speaking to a specific case that is something that has come up for us where we were representing a seller. They had a knowledge of lead-based paint, and we were told about this lead-based paint, and we did not disclose it. So, costing, our agent some money for under E&O purposes. So anyway, that's true of all disclosures where we know of something and the seller is not willing to disclose it and we know about it, we need to make the disclosure if they don't. So I'll get off my little soapbox now. All right, so then lines 30 to 54 goes on to describe the disclosure requirements for a seller. After they make their disclosures up above, they're gonna sign on line 25. And then we as agents are going to go down and sign, the listing agent is going to sign on line 119. So the certification acknowledgement of lead-based paint disclosure, so the seller requirements is continued on these following pages. I'm not going to go through it line by line. It gets through definitions as well. And then the third piece of this disclosure is the buyer's acknowledgement and certification and their option to include a lead-based paint contingency, lead-based paint test contingency. So it describes above on line 123 to 127 that the buyer has an opportunity to conduct an evaluation. And below is where they're going to indicate whether or not they want to include a lead-based paint inspection contingency. They can mark that on line 131. And then they're going to also mark 147 if they want to do a lead-based paint test as a part of their offer. If the buyer is going to waive the opportunity for lead-based paint inspection or assessment, then we're going to mark line 148. This also describes that they have been given the EPA hazard information pamphlet, and the buyer's acknowledgement again hereby acknowledges and certifies that the buyer has received the seller's disclosure, received a lead hazard information pamphlet, and received the opportunity to conduct a lead-based paint risk. So the buyer is saying, yes, I've received all of these things, and I'm electing to waive the lead-based paint contingency, or I'm electing to have it. Then the buyer is going to sign down here. So, and then the buyer's agent is going to sign on line 121. So in practice, you guys are going to pick up this lead-based paint disclosure. You're going to see that the seller has disclosed that they are not aware of any lead-based paint. Then the listing agent will sign it. We're going to pick this up as buyer's agents. We're going to sign it, and we're going to go over it with our buyer, present it to our buyer, and then they can determine whether or not they want to have a lead-based paint test done or not. So again, this applies to all properties built before 1978. If a buyer is filling this out on a property after 1978, no harm, no foul. It's okay. Okay. Any questions? I want to see real quick what we are doing our training on next week because I have forgotten already. Next week we're going to be doing the multiple counter and counter offer form, so that'll be a good one. And then the week of Thanksgiving we're going to be doing compliance and command training. All right. Excuse me. We'll cut the training there, and thank you for coming. One last call for any questions. Are you guys good? Nope. Okay. Thank you guys. We'll see you next week.